All right. Hello, welcome everyone. Today we will welcome back. We're going to discuss Chapter 3, Tort Law, using Canadian business law today. This is our, in terms of PPT, it is owned by McGraw-Hill, and it is Professor John Piccolo of Niagara College. Okay, this is for the business law class, Chapter 3. All right, there's about five learning objectives. The first one is to define the concept of tort law. Number two, then number two is to differentiate between intentional tort and unintentional tort. And number three is identify the types of intentional tort. Number four, consider the defense of unintentional torts. Number five, discuss the application of the risk management of when they're dealing with the torts. What is tort law? Tort law is dealing with an area that hold individual or business accountable for either intentional or unintentional harm caused by another person or business. So creating a harm, okay? That is basically dealing with that tort law. Provide business of the repercussion of any wrongdoing. Tort does not involve a contract between parties, and tortfeasor is the person committing a tort. This is the call it tortfeasor is the person that committed a tort. Okay, harm. What is intentional tort? It is deliberate harm. Okay, occurs when a person or business consciously and deliberately cause harm to another individual or business. This includes assault, false imprisonment, slander, and libel. Okay, that is intentional tort. What is unintentional tort? It is not deliberately to harm people or individual. It occurs when a person or business has caused harm to another person or business, but not deliberately because the professor is careless in their actions. Okay? Business exposure, action that makes business vulnerable, involves recognizing what is wrong actions or activities and how to minimize and eliminate the exposure. The business, what are the business exposure? Has the that are the things that need to be questioned. Whether the business has been documented, was it an employee or a contractor who is at fault? Was it deliberate or not deliberate? Was anyone injured? Were there any financial damages? If so, what are the amounts? Okay. The term vicarious liability is that an employer is responsible for injury caused by an employee while acting in the course of their employment. Employer may even be held responsible for the employee's criminal acts. The types of intentional tort, a party can be compensated in various ways in a situation and attempt to return of the injured party to as close as possible to original state. Okay, remedy is that to compensation, financial or other means when a person is successful in a lawsuit. It's called damages. Okay, what are the three elements that must occur in the deliberate wrongdoing? Number one is the person who committed an alleged harm defendant do it on purpose. Did the action of the defendant result in injury? Is there a monetary and material damage that has occurred? Okay, let me just go back, make sure it is, that is the one. Okay, I have accidentally pushed the button. So these are the five questions that has to be answered in terms of business exposure. Vicarious liability. Employer is responsible for injuries caused by an employee while acting in the course of their employment. An employee may be held responsible for an employee criminal act. Excuse me. What are the types of intentional tort? A party can be compensated in many ways to remedy the situation and attempt to return the injured party to as close as possible to original state. In terms of remedy, can be in terms of compensation, financial compensation, others as well. It is when it is successful and also called damages. Okay. Right. The types of intentional tort. Okay, there are three elements that must occur in deliberate wrongdoing. There's three elements. Did the person who committed an alleged harm defendant do it on purpose? That's number one. Number two, did the action of the event result in injury? Number three, where the monetary measure damage that has occurred. Example of battery and assault. Assault is an extension threat of unwanted physical contact that causes harm. Example, if a person threatens to punch another person, the person threatened can bring a lawsuit using a tort of an assault. Okay? If you threaten to person, the person can bring a lawsuit using a tort of an assault. Okay? If intentional threat, physical threat. Battery is physical, intentional, and unconsented contact that cause harm. Is unlawful offense and a tort. Example, if a bouncer intentionally harm a patron, the establishment may be facing a lawsuit. Okay? Category of intentional tort include but not limited to tort involving customer, tort involving other business, tort involving business property, tort from the words, tort from relating privacy. And then there are three main, there is a false imprisonment. If there's intentional form involves customer, there's a false imprisonment, intentionally confining an unwilling person within a specific area. For example, a store security person holds someone suspected of shoplifting until the police arrive. They must have reasonable cause to ask customer to accompany them until the police arrive. Okay? Three main types: passing off, inducing a breach of contract, interference with economic relations. Okay? Passing off. What is passing off? Falsely representing the public another company's product or service of your own. For example, purchasing a product that you thought was a designer project. This is a copycat. For example, Hermes bag. Okay, you're creating a Hermes bag that is not supposed to be there, or Louis Vuitton bag. Okay, you're selling a copycat. That is a passing off. If you see this, there's a lot of them like this available in Chinatown there. Okay, inducing breach of contract as an economic tort where a person or a person convinces a third party to breach of his or her contract within the plaintiff. Example, a business is seeking particular person for a job, opening and they went after a competitor employee to hire them anyway. Okay, that's inducing a breach of contract. Interference with economic relation, deliberately illegal interest with the third party. Example, employees steal confidential or intellectual information and give it to the competitor. This is the type of tort intimidation. There's a intimidation, okay, action with trade or unlawful act against the plaintiff. It coerces plaintiff to act in a manner which cause plaintiff to harm. Example of this: using the threat of physical harm to force a competitor to cause it to cease operation. That is intimidation. Okay? Deceit is a misleading the plaintiff using a false statement. Example here, reliance on false statement causes plaintiffs to harm, greatly exaggerating the features and the value of product being sold. Example, if the car salesman is a good example. Okay? Deceit. Conspiracy. Conspiracy, two or more defendants act together to cause harm. Combined action can cause plaintiff financial loss. Two parties working together to sell product into another seller's territory. That's another one. Three types of tort involving business property, such as trespass to land, trespass to shelter, and nuisance. Trespass to land, okay? Trespass to land means that entering or occupying land or property not owned without permission or restricting the enjoyment of property by its owner. Permission to enter someone's land can be either express or implied. So if you see some of the land, there's you see no trespasser. There is already a sign that people cannot trespass the land. Trespass to chattel, causing damage, destroying, using, or removing plaintiff's chattel. Example is a bulldozer is taken from construction site and driven away and destroyed. That is example, trespass to chattel. Nuisance is intentionally the right to enjoy real properties. Generally takes in the form of noise and odors, but can also in terms of in other instances such as vibrations. Okay, noise is a good example. A lot of noises. Example, if you create a lot of noise party or music loud, that's creating a big nuisance. Intentional fraud from the words, a harm or wrong by words, by either written or printed or spoken, must be false, must harm a person's reputation, must be heard by someone. Okay. There's three terms of intention such as defamation, libel, slanders. Okay, we're gonna go into detail of each of these definitions. Defamation, it's a false statement that must harm a person or business reputation. Okay. Slander is an oral defamation, which based on slander there is no presumption of injury or reputation. A plaintiff to required to prove that they suffer damage as a result of comment. Okay. Libel as a written defamation. If an injured party can prove libel, damages are presumed and award money is to be made compensated to the injury for the party reputation. For example, if you have a product and somebody make a bad comments intentionally to destroy the reputation of that product, then it can be liable. Okay. Injurious falsehood. When the reputation is lost because of false statement about a product service, it's also called slander goods. Example here. A competitor of a product service makes statement about its competition they are as false and reading that this statement harm of the business. For example, if somebody selling a halal food, okay, halal foods means there's no pork, no pig elements. Okay, and then somebody creating a falsehood, slander the goods that is being made by pig or non-harmful stuff. That is already injurious falsehood. It's called slander of goods. Okay. Defense in defamation of a lawsuit. The truth. The statement must be true with evidence to prove it. Okay. The key is the truth. Absolute privilege is area where you can speak freely. Parliament giving evidence is court and in regulatory manners. Okay. Defense in defamation lawsuit. What are the defense? A qualified privilege where statement may be defamatory but not malicious and are used for strict reasons such as job references. Fair comment, statement that are opinion and are not malicious. Okay. This is the defense strategy. For the public good, urgent or necessary statement that serve the public interest. The intention, thoughts relating to privacy, invasion of privacy, private information that is disclosed to unauthorized persons. For example, if your doctor cannot disclose your information to other people, okay, or unless it is authorized by you. Intrusion upon seclusion is where one intrudes upon the seclusion of privacy of another. For example, theft or personality for foreign actors or humiliation of the plaintiff. Okay. Negligence is a failure to exercise the degree of care toward another individual expected of a reasonable person in the circumstances. Most common reason for legal action based on a tort law. Key elements that must be established of a tort negligence is that four of these questions. Was there a duty not caused to harm owed by other individual to another? What are the level standard of care that was applicable if there was a duty? Did the individual action fail to meet the standard of care? Was the other person injured caused the other failures? The plaintiff must prove the balance of probability that the defendant owed the duty of care, the defendant breached the standard of care, the breach care that caused the damages. What is the duty of care? The duty of care not to cause injury is owed by one individual or business to another. It's required to exercise care toward people or business that we can reasonably foresee or predict might be harmed by our action to or failure to act. Standard care and breach of duty is this concept of duty implies that there is a certain level of standard or behavior that is expected from the person who is responsible for performing the duty. The court have used the standard or ordinary of a reasonable person. Reasonable person of an ordinary person, someone who would give careful thought to the probable result of their action before taking the first step in performing them. The standard apply not to the affected person but to an ordinary person. Causation is there must be a connection between the plaintiff's physical, emotional, and financial damage and the action taken by the defendant. The link between the act and the harm. A common question is but or for, but for the action of the defendant, what would the plaintiff be injured for? The defense for unintentional tort one is that remoteness of the damage. No reasonable connection exists between the actions of the defendants and the harm caused by the plaintiff. Court have accepted the defense that injuries were caused by some other acts and that interchange of the event outside the defendant's negligent actions. What are the contributing negligence? What are the terms? Plaintiff's own conduct contributed or caused the damages. For example, statutory defense requiring a court appropriates damages between plaintiff and the defendants according to their respective degrees and responsibility for the injury suffers. Okay, contribute negligence. The defense for the unintentional tort is that it's voluntary assumption risk. Okay, the plaintiff is aware of the risk associated with the activity that has consented to assume the risk. The risk assumed must be visible when you agree to take part as well as the normal activity being considered. For example, you take motorcycle lessons, then you are required to find a voluntary assumption risk paper there that you are assumed to be aware of the risk associated with riding motorcycle. The same thing you doing lessons for karate or kung fu or any martial art. So there is always a voluntary assumption of risk, waiver of risk, something like that form, okay? That is required to sign before you can take that classes. In terms of risk management regarding tort, as a business person, you should understand and minimize the risk in various activities. Business must train the employees and be prepared to manage their risk to avoid lawsuit. Managing risk involves understanding when the legal advice should be obtained. It is very important for you if you have a business, you must have a liability insurance, okay? If you are a professional like lawyer or doctors, you must also have a insurance, professional insurance coverage. What are the key questions? These are the key questions being asked later on in your practice. What is the tort law? What is important in terms of business? Okay, in terms of objective one. And then how can exposure to tort be minimized? Okay, what is the difference between intentional and unintentional tort? What is the remedy? What is the passing off? Excuse me. Okay, question number two. What is inducing breach of contract? Explain the 5 defenses of defamation lawsuit. What is negligence? What is the duty care? What is reasonable person in the eye of a court? And what is the contributing negligence? And those are the definitions that you need to know. And how can business reduce its risk involvement in the tort? Okay, number 5. Let's look at the key term that you need to know. Okay, this is gonna be questions in your ed puzzle. Also in some of the quizzes that are gonna be coming out. Tort is an action committed by an individual or business that cause harm intentionally or unintentionally. That is the definition of the tort. Intentional tort is a deliberate harm. Unintentional tort is not deliberate harm. Okay? Business exposure, action that makes a business vulnerable. Vicarious liability means the employer is responsible for injuries caused by the employee while acting in the course of their employment. A remedy is the compensation, financial or other, when a person is successful in a lawsuit. What is battery? Battery is the physical, intentional, and consented contact that cause harm. Okay? Assault is an intention to threat unwanted physical contact that cause harm. Okay, this is assault. When you hit somebody, that's gonna be an assault. False imprisonment, intentionally confining and arming person within a specific area. Okay, let's go back to the question number 4. Defamation is a false statement that must harm a person, a business, reputation. Injurious falsehood when reputation is lost because of false statement about product or services. Invasion of privacy is a private information that is disclosed to unauthorized person. Negligence is a failure to exercise the degree of care toward another individual expected of a reasonable person in the circumstances. Duty of care not to cause injury is owed by one individual or business or another. Remoteness to damage, no reasonable reconnection that has existed between the action of the defendants and the harm that caused the plaintiff. So the last key term, number 6, is contributing negligence, plaintiff on conduct, contribute to the cause of the damage. Voluntary assumption of risk means the plaintiff is aware of the risk associated with the activity that has consented to assume the risk. So that basically concludes this chapter 3. I will upload this in YouTube, as well as I'm going to prepare this as well as in puzzle, so you can practice and read this particular chapter in terms of terms and definitions. Guys, business law has a lot of definition that you need to understand and apply in your daily practices, so you can understand this. This is a Canadian law. It's similar to the one in the US. Okay, thank you. Bye bye.